The world is changing.
We must proceed with the vote immediately.
From the diaspora to the continent, that inspire. This is NDWG Global TV.
Good evening, good afternoon, good morning, wherever you are in the world. Welcome to Champion Network TV in collaboration with NDWG TV, and I am your host, Mija. In our previous discussion, we examined the just ended Constitutional Amendment Bill number 3, consultations, and explored concerns from the citizens, civic groups, including decision by the National Democratic Working Group to disengage from the process, citing issues of legitimacy. We also had some statement from the Human Rights Commission saying this process wasn't a fair process, and and other like the NCA as well, also citing the same issues. But in recent days, the conversation has shifted. It's now what happens to Zimbabwe, and we have had some conversations, discussions with some key political figures, including the spokesperson for the president of Zimbabwe, the spokesperson of the ZANU-PF, and the General Matatu for the Defense Forces. But the question now is no longer about the process, but about the direction of the nation. And joining me today in this conversation again is Dr. Uraya Zembe. He is not new to the platform. He's a political leader. He's a founding member of the NDWG, National Democratic Working Group, and a standing voice on governance and constitutionalism. Welcome, Dr. Zembe, to the program.
Greetings to everybody. Thank you, Chair Ramisha. And once again, greetings to compatriots who are listening and viewing this program by the Champion Network TV in collaboration with NDWG Global TV.
Thank you, Dr. Zembe. We know the consultation process has ended, and I think the next stage is for the Parliament of Zimbabwe to do the due process. Maybe for the benefit of our viewers who may not understand how this consultation take place and what role the Parliament takes in this process. Maybe you may want to take our viewers and myself as well to see what is the key role of the Parliament in the whole process of this Constitutional Amendment Bill number 3.
Yes, Parliament is a national institution that represents the nation in as far as legislation is concerned. And the legislation process is a process of enacting laws that will be used in the governance process of the country. The CAB 3 bill is a proposal to enact legislation which has impact on the fundamental instrument of governance, which is called a constitution. So the importance of Parliament is without question. The ideal is that the Parliament is an arena where people's representatives in a democracy system called representative democracy gather. Members of Parliament that we have in this country belong to two chambers: the National Assembly, which is the lower chamber, and the Senate, which is the upper chamber. Anyone who is a member of these two chambers is called an MP. How they get into these chambers currently, according to our constitutional order in Zimbabwe, is different here and there. The major one is where members of Parliament enter the National Assembly through a national election based on single member constituencies. The nation is delimited into 210 single member constituencies. And the electoral process that is used as a voting system where a contesting member of Parliament wins an election by simple majority. It means a contestant as a candidate who garners the majority votes in an election, who beats the rest, whether you have 2, 3, 4, or 10, anyone who has a simple majority, who has the highest number of voters in that election, is declared a winner. And that winner becomes the only representative of a geographical constituency in the National Assembly. What it means is that if you have, let's say you have 5 candidates vying for a particular seat, a single member constituency seat, and let's say the 4 of the members get votes that, when they are added together, constitute the majority. That is more than 51%. And the 5th member may therefore not be having votes that exceed the total of the 4 contestants. But when you look at the individual votes, the fifth member may have the highest number of votes, and therefore that fifth member will be declared a winner, even though when you add the votes of the four, it come up being more than the winner. So in a winner takes all, which may be called the first past the post voting system, it is very possible for a candidate to win an election where that candidate is voted by a minority of number of votes. That is the winner takes all method of voting. The other method is the proportional representation system. Some call it the party list system. And in that method of voting, candidates get seats that are consistent with their performance. The one who gets 30% will get 30% of the seats, let's say in a province. So the number of single member constituents in a province, let's say they are 30. And in a party list system, voters will be voting for political parties, so that the harvest is based on a percentage of on a percentage basis, such that a party that gets 30% gets 30% of the seats in a province, and one that gets let's say 20% gets 20% of the seats, and the one that gets 40% gets 40% of the seats. Now that voting method is more representative when you look at the participants. Now let's get to the importance or the focus of your question, to say what does it mean when a member in a single member constituency wins a vote to be a member of the National Assembly, that is the lower house of Parliament. Now, a declared winner will then assume the responsibilities of representing everyone who lives in that geographical area called a constituency. For example, here I'm in Mount Pleasant constituency. So when a member wins that contest, that person will represent all citizens who reside in Mount Pleasant constituency without discrimination. The member of parliament will not, according to representative democracy, represent only members of his party who voted for her or for him. That is not allowed in terms of representative democracy. The member of parliament must represent 100% citizens who live in that constituency. It follows that the decision-making process does not discriminate, as it were. A member of parliament is supposed to think in a holistic manner, representing everyone in her or his constituency, so that the best decision is made by parliament for the good of all citizens in the country. that decision should not be influenced by issues like bribery, issues like favoritism, issues like partisanship, any other issues that do not represent the totality of the people who live in a constituency would not be taken to be valid in terms of representative nature of an MP. So with regard to the current constitutional amendment processes, we are going to be entering the process where members of parliament will begin to debate the bill. Herein comes the real representative nature of members of parliament. They must represent the views of the citizens who live in their constituencies. By the way, Parliament organized some shambolic hearings that were violent, that were badly organized, that were partisan. The members of parliament were supposed to be holding their own consultations in the constituencies that they represent, so that they could get directly from the members, from the citizens, from the voters, from the people in their geographical constituencies that they represent, so that when they debate in parliament, they must state the people's will, the people's wish, what they obtained from the majority citizens that they represent. And in that way, it is expected that the decisions of members of parliament who are doing their work professionally to represent the people should mirror the decisions of the people on the ground. They should not make decisions that are favorable to their political organization. They should not make decisions that are favorable to their president of the party or of anyone, except that the decision that they make in making law should be the representative decision of the citizens who reside in constituencies. Now, this is one class of members of parliament, those who are elected by the people to represent them in the single member constituencies. Now, in the upper chamber, or even in the lower chamber, there are others who get into the House of Parliament on the basis of the performance of that particular organization with regard to number of votes that were garnered in electing members of the National Assembly. That's where you get the representative or the proportional representative method of appointing the members of parliament. There are others who represent the youth quota. There are others who represent the women's quota. There are others who are appointed by the president for their constitutional, for their professional standing. So anyone who then gets into parliament, having been either nominated by a political organization to represent women, youths, or people with disabilities, or who is appointed by the president, should again not do what the president wants. That person who gets into parliament representing women should represent ideas and the wishes of women directly in society. Those representing people living with disability should represent the interests of people living with disability in parliament, not the party that elected them, not the president who may have elected them. So, in conclusion, all members of parliament, whether they come in through a single member constituency vote or they come in through quotas of specific groups like gender, women, or the youth, or people living with disabilities, should make decisions that are independent decisions that resonate with those they represent on the ground. Not political parties, not the president, but the voters or the citizens who belong to a given class. So the MPs must therefore apply their intelligence as individuals in representing their constituents. In other words, the people that they represent, so that even in debating the Constitutional Amendment Bill number 3 of 2026, they must represent the wishes of the generality of the people. If I were to conclude here, I would then say, expect them to make decisions that represent us, the people, the majority people, our views, that of rejecting the Constitutional Amendment Bill number 3. Just a couple of days ago, I was in the rural areas in Gutu in Mashingo. I never came across any single citizen who expressed support of Bill number 3. In fact, I got a barrage of questions to say, can you inform us of what Mr. Mnangagwa and his government are trying to do and trying to achieve in proposing to extend his stay in office and the stay of members of parliament and the stay of councillors. I was asked as a senior citizen and also as an activist in terms of political leadership and human rights protection in this country. Then I also now got to discover that the people, ordinary people, are outraged and they do not want anything that is contained in that bill. What people are expecting is that Mr. Mnangagwa should pack his bags and go in 2028 as per the constitutional agreement that citizens have to say that no one should be in office as president for more than 10 years. And that one is a very strong constitutional value that the people share right across the board. And they also want members of parliament to go because they were voted for a given period of 5 years. So people are actually saying that this is not correct to ban the holding of elections, with Mnangagwa wanting to extend his stay in office, and with Mnangagwa also having bribed the members of parliament and councillors by simply saying you will also benefit, because that is what is in this amendment we are discussing. It will also benefit members of parliament and councillors in the country, and the people do not want that. And the people do not want even issues where the bill is proposing that traditional leaders should adopt a partisan membership, an open partisan membership approach, where they would become public card-carrying members of political parties, because that would be a very serious conflict with the traditional leaders. Traditional leaders have traditional values in leading their societies. Their right to lead is hereditary. It's not voted for in an electoral competition. It may be voted for in closed contests of candidates who come from houses of a clan that rule as chiefs, but that is a closed affair. We also have, in fact, this understanding among traditional leaders that leadership is rotational. It means among the family of rulers, leadership should circulate in houses. And that is, again, a value in terms of democratic governance. So, the people, including Masabuku, Namasadunu, Namadzishe, Namadzimambo, are actually finding it difficult how they will maneuver, because once they become members of political parties, open members of political parties, it will be difficult to lead and to be arbitrators where their subjects are in conflict. And it will not therefore be possible for chiefs to exercise their leadership and to exercise their judicial responsibilities, because some people will object to say, you belong to a given party, I belong to a party that you don't belong to. How can you dispense justice in that context? So the issue that political, the traditional leaders should be political is a very emotive issue. And people were even objecting if these traditional leaders adopted an open partisan position in matters in their jurisdiction. Now, this amendment will create a lot of anarchy, a lot of chaos. I got these views from the people. So let me say here that I think I've answered the first question, Lamisha, and also concluded how the members of parliament should be.
Right. Sure, you articulated very well, and but I want to push back. You've said the members of parliament are going to stand for their constituency. The people who live in their constituencies and the members of people who are elected on a representation basis, they also represent members of their group. But the question, and you clearly said the parliament is going to debate. And my understanding of a debate, you debate because you have got facts that you have got on the ground. I'm not sure if your member of parliament has been to your constituency to ask your views, so that when they go to parliament, they will come and say, members, my people in my constituency, Mount Pleasant, this is what they are going to, they are saying. We have heard, is it Richard Tangirai was trying to gather his people to get their views, and it was not allowed. So where are they going to get the ingredients to inform their debates?
What I can do is simply to suggest that they should actually respond to that question themselves directly, because they are the members of parliament. But they can canvass for ideas of their members privately. They don't have to do it only publicly. They can do house-to-house communication. They can do communication through various groupings on, let's say, weddings, or on funerals, or on house-to-house meetings with their constituent, with their groups, or with their voters, or with their citizens in their constituencies. In this area, we had Advocate Fadzai Mahere, who was a member of MP for an MP for Mount Pleasant in the National Assembly. As we know, she resigned following Advocate Nelson Chamisa's resignation as the leader of CCC. And a by-election was held, and a candidate who was sponsored by ZANU-PF won. And I've not come across any meeting that he has organized. What it means is that he will sing a song consistent with the resolution of his party, or the intentions of his party and his president, which, like I've indicated, should not be the case. That member of parliament should represent my voice as well. And I've been very vocal in rejecting, as an individual, these amendments. And also as president of the Democratic Party, the membership of the DP has been very vocal, not only in rejecting, but in pointing the dangers that such amendments can plunge the country into. I also am the Northern Region facilitator of the National Democratic Working Group, which has also announced its decision to reject both Bill number 3 and its foundation. In other words, it's the ZANU-PF people who proposed that law. And then it's the ZANU-PF people in cabinet who have now gazetted this bill. And from our readings, they added certain amendments that were not even proposed their own political party at party conferences, first in Bulawayo in 2024, and then secondly in Mutare in 2025. The membership, those who proposed, simply had their president in mind to say that Mr. Mnangagwa should stay in office until 2030. And all these other amendments, we did not hear them being discussed at the ZANU-PF conference meetings, which we also were able to read and from the media. So, back to your question. However they gather the views of the people in their constituencies, the issue remains that they are the representatives of the citizens who live in their constituencies with regard to single member constituencies, and also of the people who belong to that class of citizens regarding women, youth, and people living with disabilities. And we have reason to believe that citizens in Zimbabwe also become members of churches and groups of churches. So far we have seen decisions of churches. The Zimbabwe National Council of Churches has just given its verdict. We have also seen the Catholic bishops. They've also given their verdict. There is also the other grouping, I can't recall their name now. They've made written submissions. And as churches, they represent citizens who cut across all these groupings, either as women, as youth, or people living with disabilities, or as members of political parties, or as members of civic society. And we've also seen civil society members issuing their views against this bill. The Law Society of Zimbabwe, the Human Rights, Society or Foundation, very many groupings in our country have already made their views known publicly. So the members of parliament must actually be guided by those decisions, and so that they become perfect representatives of the people in a representative democracy system like we are having in this country. So I expect them to resonate with the views of those that they represent, the citizens of this country. So these MPs must actually, at the stage of voting, which will be done through a secret ballot, debating as they can, but the final decision making is made by the members of parliament in a secret ballot, so that the 2/3 majority that Mnangagwa and his party want should never be given to them, because everything about this bill is bad, is terrible, and has been rejected. So I think that even those who belong to, who came through ZANU-PF must represent the people, not their party, in this decision-making process. Because if they allow themselves to be bribed using money, or to be bribed using the tenure extension by 2 years, then it means they will not be true representatives of the people. And once that happens, all the liabilities that will arise from their decisions that are influenced by bribery and other factors, those obligations, these individual members in parliament will assume personal liabilities, personal obligations, and their interests will be in jeopardy, because they will have caused suffering in this country. Clearly, as a group of citizens who are supposed to apply their intellect who are supposed to represent the people in terms of these fundamental issues of survival, of governance. They will not have done justice to the people. So they will have sold out the people. They should know that they will never have peace, that they will never have their political and social interests, even including economic interests, because they will have caused death. Look at misrule that is happening in the country. Corruption, theft, drug menace. You look at the lack of employment. You look at the disaster in the health sector, where you even currently we are having nurses demonstrating, where you even have civil servants in demonstrating and not offering their services to the nation because they are incapacitated. Look at the education sector. And all these problems will actually be as a result of these MPs doing something that causes people to suffer. So I would like to think that the MPs now must do justice to the nation and must truly represent us by rejecting the passage of this bill, because the people have rejected it and power comes from the people. These MPs were voted for by the people, or they claim where they rigged the election that they were voted for by the people. That claim itself, it means now that they must never ever be influenced by trinkets, by money, by the tenure of office, because all these things will come to an end. Now, therefore, the MPs must take some of the statements we are talking about seriously. We are doing risk assessment for themselves here. They are the ones who will make important decisions, either to pass this dangerous bill or not. So my view is that they should not do so. They can debate, they can do, but at the time of voting, they should never give 2/3 vote to this bill, because that's throwing the whole nation into anarchy, into chaos, into more suffering, into total disorganization, because the people will intensify resistance to dictatorship. And I'm sure that the MPs who will have voted will be the first victims of the people's anger, of the people's struggle, and they will be victims in many ways. So it is correct that we put these risks on board that may befall members of parliament who will have betrayed the people. Back to you, Chair.
Thank you very much, Dr. Zembe. For those watching us on either Champions Network TV or NDWG Global TV, we kindly ask you to like, share, and subscribe to this channel, to the channel that we are watching. And if you have got any questions that you want to pose to Dr. Zembe here, put it in the chat box, or if you want to join us in the studio, I'll put the link in the chat box so that you can join us, and you can pose your question live to Dr. Zembe here. I hope you will be kind enough to respond. Dr. Zembe, I just wanted, you mentioned that in passing, but I just want you to clarify this to our viewers, that the voting for the MPs it's a secret vote, and it's not a vote by show of hands, because maybe some MPs might be saying, oh, we were afraid of being victimized, so we just had to go by the flow. And also, if you might also touch on the party whipping system, because we had Chabangu saying we of the CC of Chabangu, we support the bill. That doesn't mean that everybody that is within their camp will just have a group decision to say this is the vote that we have this is the decision we have to make, because according to your discussion here, every MP will make an independent decision based on their constituency, not based on what they think as individuals, because when they are in the House of Commons or the Senate, they are representing the people from their constituency. Can you just highlight on that one? Is it a secret box, secret ballot, and the number two, how do they overcome the party whipping system?
Yes, the voting method is a secret ballot, which is similar to the voting that we do in national elections, general harmonized elections. The decision of an MP will not be seen by anyone, will not be known by anyone, because they are given ballots as individuals, and then they cast their vote without showing anyone. It will only be the outcome of the voting in terms of numbers that they will know. But it is not possible for anyone to know how a person has voted. That is the answer to the first part of your question. I think that is clear. The voting is not by show of hands. The voting is not by acclamation to say, yay, or no. No, the voting is by secret ballot. And that one, as you know, a secret ballot is secret. Your vote, it's you who knows it alone as a representative of the people, as a decision maker who must represent the decisions of the people outside there when we look at enacting law. Because the current debates that are taking place and submissions to Parliament are intended to show an MP, a member of Parliament, what the popular view is. So it's a secret ballot. Let me turn to the chief whip, role of the chief whips. These are leaders of the members of Parliament who are members of their party, who urge them to behave in a certain manner in terms of how they cast their ballots. To say, when you get into a secret ballot election, please cast a vote favorable to what the party wants, or favorable to what the president of the party wants. But really, whipping members of Parliament to do so is limited in the sense that besides urging members of parliament to do so, there is no further verification in terms of voting process that a chief whip can witness regarding decision making by a member of parliament. Yes, they can urge, but they don't vote on behalf of members of parliament in a secret ballot. So the chief whip's role here is completely limited. These chief whips work in a positive manner, not in a negative manner. This bill is negative. So any chief whip who encourages members of parliament to vote yes are urging members of parliament to act in a negative manner. So the chief whip should never, be heard in this particular case. Yes, they do the whipping, but the decision maker is a member of parliament who will make a decision representing the electors, representing the citizens who will have given their ideas outside parliament in the communities. So in this particular case, I don't think that the chief whips have significant influence at all, if they have it at all. Because this matter is not a matter of public policy by a political party or by government in enacting law. Public policy of, let's say, subsidiary acts, subsidiary laws. These are secondary laws. But here we have a very serious matter that affects the fundamental instrument of governance, the primary law, if you want. So chief whips have completely, in my view, no role here to play. Should they pretend, but a member of parliament should not be changed his or her decision based on what the people want by a chief whip. Because these chief whips are also members of parliament. They also vote as in a secret ballot. So why should members of parliament be influenced by other members of parliament to the extent of betraying the people or the electors or the citizens regarding such a fundamental proposal, which is actually overthrowing the constitutional order itself? Because this bill number 3 has the effect of overthrowing a constitutional order. It's changing a lot of fundamental aspects of governance. Appointment of president, midstream. We have had this as a tradition now where president is directly elected by citizens, where the country is one constituency, the whole country, and electors electing. We are even saying that people in the diaspora should have a vote, should be able to vote from the diaspora to vote for a president directly. And now if they are now saying in this bill that the president should be voted for by members of parliament. Now that's a fundamental change. And that change cannot go through because it was not originated by the citizens of this country, the people. It's originated by a political party, and the political party has interests, ZANU-PF, and their members. And then they come to the nation. These are public institutions of governance to overthrow a constitutional order. the people's highest law, if you want. Now, it cannot be heard that a person is influenced by a chief whip to make such fundamental decisions. No. MPs should be influenced by what the people have expressed and what the people have mandated them to go and do in Parliament. Now, if let's say this proposal had started from among the citizens of this country before it was approved by cabinet and before it was gazetted, definitely the citizens of this country would have said no to these proposals. And that would have been the end of it. Now that it began from one political party into the instruments of governance, cabinet, and the cabinet approves it, chaired by Mnangagwa, who will benefit from this law. And all these MPs, no, not MPs, ministers who sit in cabinet, will benefit from this law. That is a direct conflict of interest, which in modern day philosophy of governance should never be tolerated. You know, you can't begin to do things that will benefit you using public offices. No. For private gain. No. So the principle is clear. No chief whip should be heard by all MPs. Even the chief whip himself or herself should represent the people, not his party, not his interests, not his president's interests, but the majority views. Because the public law is intended to look after the interests of the majority citizens of this country, if not all citizens. You may have a minority who are thinking negatively, but who also benefit if a good law exists. If a good decision is made, it will benefit even those few who wanted to monopolize the benefit themselves. So these members of parliament should never listen to their chief whips who may agitate for a yes vote of such a terrible piece of legislation. Back to you, Chair.
Thank you very much. I think this ties up with the next question, because I think the chief whip is all about influence. And we have heard powerful voices like the General Matatu, who is the commander-in-chief of the National Zimbabwe Defense Forces, saying they support the bill. What do you say to that?
This is not new. We have had the army commanders in this country, or defense forces commanders in this country, pronouncing views like this country cannot be led by someone who did not go or who did not participate in the armed liberation struggle. We have had these views made publicly, for example, by the former commander of the defense forces, Zvinavashe Musungwagava, who said that the post of president is a straitjacket, and that post can only be occupied by people who have been to the armed liberation struggle, those utterances were made. We've heard people like Nika Aramba, who was a general who made such utterances openly. We have heard many more servicemen who made public utterances like that. Now, the question is, Matatu should know that as commander of the defense forces, he should be aware of his job description and the limitation of his job description as a serving general. And it is not proper that he has announced openly and publicly that he himself supports the bill, and all the forces he leads support the bill. He should not have made such utterances, because it is the people as individuals, without regard to our occupations, who should make such decisions. Him included, but acting in a civilian manner in terms of decision making, without claiming that all the soldiers support the bill. That is not correct. Definitely that should never be the case, because soldiers represent packaged people's political power to defend the nation against foreign enemies, against foreign invasion. And decisions of governance are made by civilian people, including the service people, but acting as civilians, not in military fatigue, combat, not while they are on the job as soldiers. You see, this is an aspect that Zimbabweans have never been influenced with. Even where Generation the Nika Rambas have been coming out open, ZANU-PF candidates as presidents have been losing elections, because it is not the business of the generals to dictate to people how they should decide in terms of the legislature, the process of enacting laws in a country. That's not their mandate. It's not part of their mandate to make proclamations like that made by Matatu. No. In fact, he was abused to make such a statement. The service people should just be quiet and go about serving the people, and then when it comes to decision making through the secret ballot, they will do so. Now, the other generals who are no more serving this nation can come out open. They can, because they are no more serving the nation. They've retired. So they can make their views known in terms of responding to this proposed law. There's nothing wrong in a retired servicemen and women making their views known publicly, should they decide to do so. But to a serving member of the security forces, professionalism demands that they should just simply act without making such public statements, because those public statements, the real intention is to intimidate the people, to frog march the people into saying, into voting, into accepting something that will not serve the people themselves. You see? So this is why, in terms of the current constitutional order, public servants, generals included, are not supposed to be partisan. They are not supposed to be card-carrying members of political parties. It is for that reason that they are servants of the state, they are servants of the people without segregation. Yes, they can vote because it's a secret ballot system. They are citizens of this country. Yes, they can discuss about when they remove their military attire and they mingle. They can discuss as citizens of this country. They can participate in voting processes that are secret, and then their decisions can be put through. You know, no, but not to come out for a law which is being proposed, which is under consideration, to say we support it. We as who? How have they voted as the soldiers for Matatu to announce a majority vote of all servicemen and women? There is no requirement like to get to the vote or the sense of service men and women. There's no such a requirement. So how did Matatu arrive at his announced decision? Never. So the people, in fact, have rejected such pronouncements by army generals who are in the service of the nation. And I am sure that, Matatu's statement will not change the verdict of the people to reject the Constitutional Amendment Bill number 3 of 2026. The die is cast, the decision has been made by the people. They have made their decisions publicly as individuals, as various groups of political parties, groups of churches, groups of interest groups, professional groups, and citizens continue to make their voices loud and clear that this bill should be withdrawn and that this bill should be resisted. This is why the people are now focusing on the members of parliament, that they should make a decision that protects the interest of the nation by simply saying, no, the people have rejected this bill, so all members of parliament should vote no in a secret ballot. Then they will have served the nation, not serving a political party, not serving an individual person or a group of persons, but the nation. Back to you, Chair.
Thank you very much, Dr. Zembe. I think the other bit of this conversation, we are going to frame it for our next conversation. Hopefully, we will do it again tomorrow when we discuss Charamba and Mutangwa, and hopefully also the proclamation by the members of the upper house here regarding readmission into the Commonwealth. But let me go to towards our final. We now want to look at the wider picture where Zimbabwe is going. When we bring all the voices that we've talked about, government, political parties, security perspective, and us as citizens, what picture emerges about the direction Zimbabwe is now taking? Are we moving towards a greater inclusion, centralization? What does this moment say about the state of our democracy in Zimbabwe?
Yes, that's a difficult question, but I can proffer my thoughts. What I see is a convergence of national thinking regarding constitutionalism. And this will revive the discussion of the status of the nation in terms of whether our country is independent or not, whether our country is a republican state, constitutional state or not, whether our country has a people-driven constitution or not. And this convergence can only be positive because we have had ZANU-PF rule for the past 46 years. And the ZANU-PF itself is no more one political party movement. ZANU-PF itself has been hijacked. ZANU-PF itself has been malfunctioning because its government has failed the nation for the past 46 years. And the latest being the past 8 years that Emerson Mnangagwa was in office, and the past 13 years that the Constitution of Zimbabwe Amendment number 20 Act of 2013 has been the governance instrument. There is more failure in the past 13 years, which means that the constitutional order has failed. It now has occupied the center stage of discussion in the country. Clearly, that is the evidence that the 2013 Amendment Act Constitution is less than people-driven in terms of its enactment. It was never, therefore, a people-driven constitution. Because anything that is driven by the people cannot fail. If we had a truly people-driven constitution then, 13 years later, we would not be seeing underdevelopment that we are seeing. We will not be seeing failure that we are seeing. We will not be seeing all these problems we are witnessing. This is the convergence and the realization and the awareness that is beginning to take root in the country, regardless of the partisan position of citizens. We are, as a nation, beginning to think about whether we are an independent state from British rule or not. And some have actually advocated the fact that Britain still has a colonial obligation to help Zimbabweans create their own people-driven constitution. It is the Zimbabweans who came up with this idea of a people-driven constitution. In the Southern African Development Region, in the African continent, and in the whole world, it is Zimbabweans who came up with this philosophy of a people-driven constitution. That is the desire of Zimbabweans. And this is why some citizens of this country embarked on how a people-driven constitution should be produced by the people themselves. How should Zimbabweans author their own constitution so that they can have a people-driven constitution? And the studies have been done. And like I indicated in the previous discussion here, Dr. Zembe conducted that research from 2011 to 2016. And there is therefore a blueprint on the table for Zimbabwe to adopt so that Zimbabweans can be able to produce, to write their own constitution. Writing is thinking of constitutional values and allocation of political power in the constitution, in arms of government or structures of government. And once that is done, a lot of problems will be resolved by our nation. Because anything that is centered on popular people opinion has maximum national wisdom and cannot fail the people. We will have problems, they will be exposed to the people, and the people's intelligence, the people's wisdom should guide national governance, democratic governance. So I'm seeing this development happening because then it will resolve problems of the country, at the same time unleashing development, sustainable development, because there will not be misrepresentation. And anything that we do following popular opinion will succeed, will be in the best interests of the nation, of the people. So we are on course to overcome national problems that have their roots in colonial rhodesia, which have been continued during the past 46 years under ZANU-PF Mugabe Mnangagwa rule. And we are beginning to see people from various political formations coming out, looking at the problem, being honest, embracing each other as a nation, which should actually proclaim independence once a people-driven democratic constitution is authored and is in existence. That's the proclamation of independence. Because you can't talk of independence when people have not enshrined their instrument of governance as a constitution. So that's where we are marching towards. Even looking into the responsibilities of the former colonial master, which were not abolished after the Lancaster's constitution. The privileges of the 20 white seats were supposed to be abolished after 7 years. That's when this nation was supposed to embark on producing a people-driven democratic constitution. Way back in 1987, But the ZANU-PF political party and the members privatized the instrument of governance, the Lancaster House Constitution as amended, and continued to amend it without people's involvement, without surrendering the matter to the people over the years. And this is why this nation is having to resist what Mnangagwa and the company want, which could not be the case if we had a truly people-driven democratic constitution. So that's where we are marching towards, as far as I'm concerned. And we can only be winners, not losers as a nation.
Thank you very much. Thank you very much, Dr. Zembe. And you know, in my language, it's not Chisingapere, it's not I say. You know,
Sure, I'm sorry.
Right. It's like, so we are parking here. We haven't exhausted all the points that we needed to discuss, but we are going to resume. I think you spoke quite heavily on the issue of the constitution, and I think also we had George Charamba alluding that there is no constitution in the United Kingdom. And we were going to discuss that, and also we were going to talk about what Mutlangwa was talking about with regard to the Amendment Bill number 3, and a number of things that we are going to. So we are going to, if you are available tomorrow again, around the same, it will be a bit later, we can then reconvene and we discuss other issues. But in just 1 minute, anything you want to say to Zimbabweans watching at home or in the diaspora?
Yes, Zimbabweans should continue engaging in discussions, in discourses progressively, and contribute to our thought processes, and also taking affirmative action in an orderly, peaceful and progressive manner. And peaceful processes are stronger than unpeaceful processes. Peaceful processes are stronger than dictatorship processes. And when people embrace, they can defeat all the acts of violence that may be produced by minorities among us. So Zimbabweans should continue to be bound by the power of positive thinking. It is us who can reshape our future. It is us who can redeem ourselves from the mess we have been plunged into by those who have been in the instruments of governance. Those who have failed, those who became corrupt and became selfish while occupying public office have failed the nation. And the nation is taking stock of the failures, including the population that embarked on the armed liberation struggle. The surviving members of the armed liberation struggle are beginning to think and to remind themselves and the nation of the reason why this nation went to war. And this is the beauty of Mushaidare. Mushausnadare Wakafa. You know, the assemblages where individuals address problems, community problems, communal problems, national problems, and begin the process of thinking. As you know, we think as individuals, not groups. Groups don't have a mind, human mind to think. It is individuals who think, and through individuals, we have a collection of thoughts, and we get the best thoughts, the best decisions, the best policies out of group discussions. So therein lies the importance to give an individual citizen the right to think, the right to associate, and the right of actually being heard. This is the fundamental in terms of human activities. You must have individual rights of thought, the right of conscience, the right to say, and the right not to say. Therein lies the question of even public demonstrations or public petitions to authority. Where the community decides to inform those in office of their feelings about public life and even about private life, the issues of governance. So let's continue to be bound by the power of positive thinking. We have the power to correct the wrongs that have affected this nation. And if we don't, then we will perish. Then we will destroy the future of the preceding generation. And that is not cultural. I mean, most of us, we belong to cultures in Zimbabwe that believe in a concept in Naka, that we should be able to leave positive legacy for our children and our children's children, so that they have somewhere to begin from in future. We can't destroy the lives of our children and grandchildren by being selfish and simply considering our own gratification as a generation. So please, we must encourage each other, whether we are here to home or in the diaspora, to address, to discuss issues of our nation, issues of governance, of management. Therefore, we can regenerate as a nation. That's my passing, my concluding note, Chairman.
Thank you very much. Those were very powerful insights, and I think the central theme in this discussion was the MP have got a responsibility, one, to listen to their constituencies, and when they debate, they must debate from a position of being informed. And when they go to their ballot, that's a national duty, and it's a secret ballot, and they have to reflect the will of the people. And well, of course, there will be those chief whips who want to influence your decision. But when you get to the ballot, you are on your own. Yes, there might be powerful voices that might want to whisper you to change what you think, like General Matatu, and there are other people who have said quite a number of things. But we must take the views of our generals. We have got also our generals like General Muchena, our Comrade Knox, who is coming out and talking to us about what position to take. So it is up to us which voice do we listen to. So, Dr. Zembe, thank you for joining us here on Champions Network TV in collaboration with NDWG Global TV. Your insights were very powerful. And what was clear from our discussion is that Zimbabwe is at a critical point, and it needs people who think, it's people who discuss, people who can have all opinions on the table. And the central question is, does Zimbabwe have our own constitution? Or we are just working with an amended colonial constitution that we were handed over from Britain? I think in our next discussion, We'll dive deeper into that. We are hearing strong opposition to the government, political actors, and from those concerned with the national. But ultimately, the enduring question is whose voices carries the greatest weight in shaping the nation's future? This is a measure of the Champions Network TV in collaboration with NDWG Global TV. Wherever you are, until next time, this motto is the same. Stay informed, stay engaged, and let your voice matter. And a nation's future is not decided by voices alone, but by whose voices are heard. So from us this evening, good evening until we meet again, hopefully next tomorrow.
To help us grow, please give us a big thumbs up, share this video with your network, and hit that subscribe button right now.